Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers vehicle searches, protective sweeps, and the exclusionary rule, and is brought to us by the Disorderly Product News channel. Be sure to check out the description below and give them the credit that they deserve. On July 29th, 2019, the owner of the YouTube channel Disorderly Product News, who we will refer to as Mr. Disorderly, was stopped by Officer Stephen Gregory of the Chicago Police Department for allegedly not wearing a seatbelt. Mr. Disorderly immediately began recording the interaction with Officer Gregory on his phone. Officer Gregory asked Mr. Disorderly why he was leaning over in his seat as he was being stopped, and Mr. Disorderly replied that he does not answer questions. After a brief exchange, Officer Gregory orders Mr. Disorderly out of the vehicle, and Mr. Disorderly reluctantly complied as other officers from the Chicago PD arrived on the scene.
Everything's on camera, brother. If you got nothing to hide, you got nothing.
We're all being recorded.
Step back over there. Step back over there.
That's fine. I just want to let you know.
What are you doing? You're just being detained.
I'm patting you down, make sure there's no weapons.
To do a cursory search of my person.
It's a pat down.
Why is she searching my car? Why is she? I did not give her permission to search my car.
Just relax.
Me leaning over is not a crime. No. That's not exactly. You don't know. You had that clear articulation. You just said that. You just said the magic words.
We don't
Keep your hands up here.
Exactly.
Hey,
you
keep
don't
your hands
know.
up here.
And you
Keep your
need
hands
to
up
have
here.
clear and articulable evidence if I
Keep your
am.
hands up here.
You need to have clear and articulable evidence I am. So you saying you just don't know?
You got insurance on the car, Joseph? You have
Where's your
insurance?
Why is she in my car?
Do you have insurance on the car?
I'm not. Why is she in my car?
Do you have insurance on the car?
Of course I have
Because
insurance.
I wanted to see what you were leaning
Get
over
out of my
doing.
car.
Don't tell me what to do.
After Mr. Disorderly exits his vehicle, an officer conducts a pat-down search of his person, and Officer Kimberly Opetisano begins searching Mr. Disorderly's vehicle without obtaining his consent. Because individuals have a lower expectation of privacy when driving a car than they do in their homes, the courts have carved out certain exceptions to the Fourth Amendment warrant requirement that allow an officer to conduct a warrantless search of a vehicle when consent is given by its owner, when there is probable cause to believe there is evidence of a crime in the vehicle, when a protective search is necessary for the officer's own safety, and when the suspect is arrested and the search is conducted pursuant to the arrest. Over the years, courts have resolved hundreds of fact-specific cases dealing with these four broad categories, and a long line of Supreme Court cases has created a complicated and nuanced set of rules about warrantless vehicle searches. For example, in the 1996 case of Pennsylvania versus LeBron, the court held that, quote, if a car is readily mobile and probable cause exists to believe it contains contraband, the Fourth Amendment thus permits police to search the vehicle without more. In addition to allowing officers to search the vehicle, the motor vehicle exception permits officers to search containers inside the vehicle, including the glove compartment in some situations. As the court explained in the 1979 case of Arkansas versus Sanders, where it held that a warrant generally is required before personal luggage found in a vehicle can be searched, quote, not all containers and packages found by police during the course of a search will deserve the full protection of the Fourth Amendment. Some containers, by their very nature, cannot support any reasonable expectation of privacy because their contents can be inferred from their outward appearance. Similarly, in some cases, the contents of a package will be open to plain view, thereby obviating the need for a warrant. The court also acknowledged, quote, there will be difficulties in determining which parcels taken from an automobile require a warrant for their search and which do not, and deciding whether a container found in a vehicle can be searched is a highly fact-specific analysis. We will discuss the legality of Officer Opetisano's search of Mr. Disorderly's vehicle later in this episode, but for now, it's important to note that there are some situations where an officer may search a vehicle or its contents without consent or a warrant.
Where's your insurance?
Okay?
You want to see what I was leaning over getting? It was my phone. It's on me.
Hey.
It's on me. My phone.
Okay,
You
good
have
for
no
you.
right to be in my car.
You don't know the law.
I do.
Oh,
It's
you
called
do.
Terry versus Ohio, 1962.
Joseph.
Yeah,
Set precedent for the Fourth Amendment to the Constitution. You know what the Fourth Amendment to the Constitution
Yes,
is?
I do.
Okay,
Yes,
tell
I
me
do.
what it is.
Do you have
I'm
Tell me
insurance?
not
what it is.
explaining myself to you.
Unreasonable search and seizure. Get the out of my car.
Hey,
Do you have
Okay.
insurance on the car?
You have
Of course I have
this
insurance
car?
on the car.
Okay, well,
She
what
has
is it?
no right
Why
to
are
be
you-
in
why
my
are you
car.
acting like this?
Because you're
Is there
breaking
insurance
you're
Where's your
breaking my
insurance?
constitutional
Hey.
rights.
Where's your insurance on
just
the car?
insurance. Where's your insurance?
It's in my car.
Okay,
Where
that's
in the
where
car?
at in the car?
I
It's a
don't know.
four-door
I don't
car.
know. You pulled
Would
me
it
over for a
be?
seatbelt.
Right.
A seatbelt. Why are you in my car? Because I leaned over.
Because you leaned over, you could be
That's
hiding a
clear
weapon.
enough.
I don't know
Okay,
that
you just did a
unless
cursory search of my
No, I
person.
didn't. I did a
You
protective
did a
pat down.
cursory
I
search
didn't
of
go
my
in your
person.
pocket. I
I
touched
know
your
you
outer
didn't.
guard.
That's a cursory search.
It's called a
Just keep your hands
protective
up
pat
here.
down.
Oh my
Relax,
God,
relax.
dude. I'm telling
He
you.
has
You did the-
insurance on the car?
Where is the insurance?
Where's the insurance?
In the car.
Where?
Where at it?
We've already had this conversation. I don't know. I had to be in the car and look for it.
Well,
Point-
be my
point to
guest
where-
now.
point to where-
Be my guest? Okay, I will. What are you doing,
Hey,
dude?
Close the door
Just
on
relax.
on my hand.
Relax,
You
dude.
put your hand in the middle
Let
of
me
this
see the
traffic.
insurance.
Just find your insurance. Appreciate it. Thank you. Hey, Vic. Oh, you got it? Hey, just stay calm, bro. That's all. Just stay calm. Just stay calm.
I didn't do anything wrong.
It's understandable.
You have valid insurance? This expired March 11th, 2019.
This was effective March. What does that say? Expiration date 3/12/2020.
Relax.
And you're the one searching my car. You're searching my car. You can't even read a insurance.
Hey,
You're a
There you go, sir.
yeah.
Hurry up, you better.
Yeah. Hurry up. Hurry up.
Sit tight.
hey, just
Yeah.
relax. Hey,
Hurry up.
hey, relax.
Hurry up. And bring back your ID cards. Bring back your business cards. Make sure you do that. No, bring back your business card.
Hey, relax. Come on.
You're out of your
Relax,
mind,
bro.
dude. You're out of your mind. How
Relax.
dare you go in my
Relax.
How dare you go in my car?
Relax, bro.
Unreasonable search and seizure. He said because I was leaning over. What crime is that? What crime is it to lean over in your own car?
The officers state multiple times that they searched Mr. Disorderly's vehicle because one of the officers allegedly witnessed him bending over in his car as he was being stopped. And Mr. Disorderly continues to argue that the search was unconstitutional because leaning over in your car is not a crime. In this situation, it appears that Officer Opetisano's warrantless search of Mr. Disorderly's vehicle was predicated on the notion of officer safety, which would implicate the protective search arm of the Fourth Amendment's automobile exception. And the courts generally grant police officers broad leeway to search vehicles in situations where they believe they may be in danger, regardless of whether there is reasonable suspicion to suspect the individual of a crime. In the 1983 case of Michigan versus Long, the Supreme Court noted that, quote, "Our past cases indicate that protection of police and others can justify protective searches when police have a reasonable belief that the suspect poses a danger, that roadside encounters between police and suspects are especially hazardous, and that danger may arise from the possible presence of weapons in the area surrounding a suspect." Based on these principles, the court concluded that, quote, "The search of the passenger compartment of an automobile, limited to those areas in which a weapon may be placed or hidden, is permissible if the police officer possesses a reasonable belief based on specific and articulable facts which, taken together with the rational inferences from those facts, reasonably warrant the officer in believing that the suspect is dangerous and the suspect may gain immediate control of weapons." Applying this standard, lower courts have often upheld protective searches of vehicles based on the driver making so-called furtive movements, such as bending over when pulled over, as such movements could be consistent with hiding a weapon. For instance, in the 2019 case of United States versus Vaccaro, the Seventh Circuit, which includes Illinois, upheld the protective search of a vehicle based on furtive movements, including bending forward at the waist and reaching toward the passenger and rear seats, that, quote, "reasonably suggested that he could be reaching for or concealing a weapon." Based on Officer Gregory's statement that he saw Mr. Disorderly reaching over to the passenger side of the vehicle, it is likely that a court would find Officer Opetisano's search reasonable, given that she only searched the immediate area in question and did not search the entire vehicle.
Just relax, bro.
You guys are
Relax.
out your mind, dude.
Sir, would you like me to explain it to you, or keep yelling?
I don't need you to explain anything to me.
All right.
Because you know the law, you know everything?
I do know law. I do know law. It has to qualify as a
So you
Terry
just wanna
stop.
keep yelling?
It has to qualify as a Terry stop.
No,
He
it's
took
okay.
me out of the car because he believed I had a weapon on me, so he can do a cursory search of my person for a weapon. They by no means can enter my car.
Why did he believe you had a weapon on you?
Where'd you
You
reach
have to ask him.
Hey, where'd you reach to?
Did you lean
What?
over?
Where'd
Because
you
I
re-
leaned over. That's why he believed I had a weapon.
Because it is no.
So
It is when somebody gets pulled over and they want to hide something, you see their head go down and do some stuff. Reasonable suspicion to believe, okay, maybe you are hiding something.
okay.
Reasonable suspicion. It's not a crime to lean over.
Okay, but then I'm doing what? What's the crime? Reasonable
hiding
suspicion of what crime?
He's seeing if you're hiding a weapon or something.
Dude, that's so okay. Keep that. That's got to be your defense in court. Somebody
That's what I'm
bending
trying to tell
over.
you.
Somebody moving. That's
Bending
if I
over,
was
yeah.
moving. I'm not even saying I was moving.
We don't know what happened. You
just said
seen
you
when we rolled up
I never said anything. I
said
said
it
that's
over.
what he said.
You said you leaned over.
for your
I,
phone.
I said I leaned over.
It's on camera. Yeah, you said you leaned over
I
for your
said
phone.
she asked me what I was getting. It was my phone on my pocket. That's not leaning over here. My phone was in my pocket.
Like I said,
That's not
we
legal
pulled up
there.
after the
That's-
fact.
that's what I'm
Remember,
trying
you
to
seen us
explain to
pull
you,
up
that's why.
after the fact.
The officers tell Mr. Disorderly that he has already admitted to leaning over, and the body camera footage clearly shows Mr. Disorderly telling the officers that he leaned over to get his phone.
Where's your insurance?
Okay?
You want to see
When
what I was leaning over getting? It was my phone.
Here
It's
you
on
go.
me.
Hey,
Under the so-called exclusionary rule established by the Supreme Court in the 1961 case of Mapp versus Ohio, quote, all evidence obtained by searches and seizures in violation of the Constitution is inadmissible in a state court, and earlier Supreme Court decisions apply the same rule to federal courts. This means that if any evidence is discovered during an illegal search of a vehicle, a criminal defendant can file a so-called motion to suppress, and if the court agrees that the search was illegal, the prosecution cannot use any of the evidence obtained from the search to prove that the defendant was guilty of a crime. Here, the fact that Mr. Disorderly admitted on video to leaning over could have affected his ability to suppress any hypothetical evidence found during a search of his vehicle. If Mr. Disorderly had been arrested based upon something found in the search and requested that the evidence be suppressed, the prosecution could use his admission to bending over as evidence that the officers had a reasonable belief that he was dangerous and might gain immediate control of weapons. Absent Mr. Disorderly's admission, it is likely that the only evidence that Mr. Disorderly bent over in his vehicle would be the officer's testimony, which could potentially be discredited during a suppression hearing. Of course, because Mr. Disorderly's movements were the only reason the officers cited for their suspicion, there is still a legal argument to be made that the search was unconstitutional. But Mr. Disorderly's case would be stronger if he could also challenge the factual basis for the search. This is a perfect example of why criminal defense attorneys generally advise citizens to not talk to the police. And it is important to bear in mind that anything said during a police interaction can impact subsequent legal proceedings. In this situation, Mr. Disorderly certainly could have benefited from invoking his right to silence, as he essentially would be unable to challenge the officer's assertions that he bent over in the vehicle because he admitted to doing so on camera.
they'll give you what's called an ISR receipt, all right? Investigatory stop receipt with his star number and all that, okay?
If anybody's been a gentleman here, it's been Bruce. And I understand.
I appreciate you being calm, yeah. I appreciate you being
I
calm.
understand you have to back these guys up, but they were totally out of line. Completely out of line. I have done nothing wrong. I am a hardworking American. I pay my taxes. I own my own business.
Okay.
To be pulled over for a seatbelt and then she's digging through my car?
Like I
They're
said-
narc officers. They don't pull over people for seatbelts. They pull
Like-
people over for drugs.
Yeah, like I said.
Because I'm white in a black neighborhood. That's exactly why they pulled me over.
All right, they'll explain all the citations to you. If,
He didn't even have a ticket book. He had to
Joseph,
get
here
it
you
from
go, buddy. There's your license back.
What's your name and badge number?
It's Gregory. It's right here. I'm going to give you the
I don't
receipt.
care about that. I'm asking you. Tell me
It's right
what
here.
your name.
Gregory,
No.
9960.
Gregory 9960.
Mr. Disorderly was eventually issued a ticket for not wearing a seatbelt, and he left the scene without further incident. He disputed the ticket and attended the court hearing, but the officers did not show up to court, and the ticket was dismissed. Mr. Disorderly filed a Freedom of Information Act request with the Chicago Police Department to obtain the body cam videos of all the officers present at the scene. Unfortunately, he only received 2 body cam videos, despite there being 4 officers on the scene. Overall, the Chicago Police Department officers get a C, because although they were likely within their authority to search Mr. Disorderly's vehicle for a weapon, they maintained hostile and combative demeanors throughout the encounter, condescendingly dismissed Mr. Disorderly's concerns about the search, and failed to take any actions to de-escalate the situation. The officers likely could have changed the entire trajectory of this interaction by empathizing with Mr. Disorderly, acknowledging the validity of his concerns, and engaging in a meaningful conversation about the legal authority officers have to search vehicles. Had the officers provided a patient and sympathetic explanation of the law in this situation, they could have created a much more positive experience for Mr. Disorderly and improved his understanding of the law and his overall view of the police. This interaction shows the impact that an officer's demeanor has on the way the citizen perceives a police encounter and the impact that encounter can have on police-citizen relations in general. Mr. Disorderly gets a B, because although he was likely incorrect about the lawfulness of the officer's search, and he failed to fully exercise his right to remain silent, he complied with the officer's orders, voiced his opposition to the search without interfering with the stop, and followed up this interaction by filing a Freedom of Information Act request to obtain the body camera footage. It's important to note that Mr. Disorderly was not an auditor or constitutional activist at the time of this encounter, and for this reason, it's perfectly reasonable for him to be upset about what he believed to be an unlawful search of his vehicle. As we previously discussed, the officers failed to explain why the search of his vehicle was lawful, and without the legal background needed to understand the legality of protective searches, it makes sense that Mr. Disorderly would think the officers needed reasonable suspicion of a crime to search his vehicle. By disregarding Mr. Disorderly's complaints, instead of taking a moment to explain why the search was legal, the officers missed a valuable opportunity to build rapport and help further educate Mr. Disorderly about his rights. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.